Good evening, everyone. Welcome. Welcome to Plymouth Church. No matter who you are or where you are on life's journey, you are welcome here. So welcome. My name is Valerie Miller-Coleman. I'm senior pastor here. I'm delighted that you've chosen to join us this evening. Thank you for being part of this important conversation. The history and legal context of abortion rights in the United States frame our current understanding of reproductive justice and the kind of moral leadership that's needed in this moment. So that we may better reflect on that context, the focus of our conversation tonight will be abortion rights in legal and historical perspective. This is the first installment in a series of 3 public conversations on abortion rights hosted by Plymouth Church here in the sanctuary. The next 2 conversations will be Wednesday evenings, July 20th and 27th. You can read more about that on our website at PlymouthLawrence.com or on the flyer you received on your way in the door if you're joining us in person this evening. If you are here in person tonight, you also received a note card for use. Any questions you'd like to ask our speakers, you can send them forward, raise a hand, one of our ushers or I can grab those from you, and I'll bring them and address them to our speakers. I cannot promise we will get to them all, but we will address as many as time permits at the end of the evening. Again, welcome. Our moderator this evening is Plymouth member Professor Eleanor Schrader, Paul E. Wilson, Distinguished Professor Emeritus of Law, the University of Kansas School of Law. Eleanor?
Thank you, Valerie. Well, we have 2 terrific speakers. They're going to share their knowledge of the legal and historical perspectives of abortion rights with us, and we thank them ahead of time for the time and effort they put in preparing for this evening. Thank Rick and Betsy. So I'm going to introduce both of them, and then they will each speak. And then after they're all done, then we'll have time for questions and comments that you put on your cards. So we won't take a pause between Rick's talk and Betsy's talk. So Rick Levy is a J.B. Smith Distinguished Professor of Constitutional Law at the KU Law School. He's a nationally and internationally known teacher and scholar in the field of American public law, which includes constitutional law, administrative law, and legislation. He joined the KU Law faculty in 1985 after finishing a clerkship for a judge on the 7th Circuit Court of Appeals in Chicago. Rick is a prolific scholar and has an extensive publication record in leading journals. He's also an author and co-author of a number of books on administrative law and constitutional law. He also has given extensive service to the state, including work on comprehensive reform of the state's administrative procedure and child in need of care laws, as well as offering expert testimony for various legislative committees in the Kansas legislature. In recognition of this service, the university awarded him the very prestigious Steeples Award for Service to Kansas in 2010. He's also had various positions of leadership in the university, including president of the faculty senate, chair of the judicial board, and he's also helped do comprehensive rewrites of several codes within the university. Betsy Esch has been an activist since the 1980s, when the pro-life movement began its campaign of terror against women seeking reproductive health care. As a student, she worked to defend clinics in Southeast Michigan, both politically and physically. She's worked both in the U.S. and internationally to support the rights of incarcerated women and against the U.S. military. Before pursuing her PhD, she lived in the Israeli-occupied territories, where she worked as a journalist and in support of Palestinian legal, economic, and human rights. She's a faculty member in the Department of American Studies at KU, where she teaches courses on race and racial identity, social justice, power, and structures of inequality, on the relationship of the United States to the rest of the world. She has published work reflecting these interests, including The Production of Difference, Race and the Management of Labor in U.S. History, co-authored with KU Foundation Professor David Roediger, and the color line on the assembly line, managing race in the Ford Empire. So thank you to both of our speakers for being here tonight, and Rick, we'll start with you.
Let me begin by thanking Valerie for inviting me to participate, and Eleanor for the kind introduction, Betsy for being on the panel, and all of you for coming out. I know it's something to ask people to come out on a summer evening to talk about important and weighty issues. So I'm very grateful to have this opportunity. Let me see if I can make this work. So my goal today really is to help you by providing context and background. So I'm going to assume if you're here, you've been paying attention and you know about the Dobbs decision, you know, and have read commentary about the decision, some discussion about its implications and the like. And my idea was, if I can provide you with some deeper background than you might get from conventional news accounts, you'll be in a better position to assess the issues and reach your own conclusions about Dobbs and its implications. So to make that work, I'm going to start by talking about the concept of substantive due process. And when I talk about this topic, we're going to have to go down a little bit of a rabbit hole as we pursue very complex ideas about the meaning of constitutional provisions. That will then provide context for us to think about what it is exactly that Roe v. Wade and Casey held, why the court in those cases deemed the right to have an abortion to be protected by the Due Process Clause. Then I want to talk a little bit about the conservative critique of Roe and Casey that emerged actually almost immediately after Roe and gained in momentum and volume and eventually led to the reformation of the court and Dobbs. Then I would like to give you just a brief summary of some of the legal issues after Dobbs and discuss abortion rights in Kansas. And I have about 20 minutes to do that, so wish me luck on those things. So let's start with substantive due process. And here what we're thinking about when we talk about substantive due process, we're talking about the protection of substantive rights by the Due Process Clause of the 5th and 14th Amendments. Now, to understand substantive rights, you have to start with the Bill of Rights, which are the first 10 amendments to the United States Constitution, adopted very shortly after the founding, which enumerate a number of explicit rights like freedom of speech, free exercise of religion, to name a couple that have been in the news recently. Now, a lot of times people talk about the right of privacy, but there is no right of privacy listed in the Bill of Rights, no provision in the text of the Constitution that protects the right of privacy explicitly. Now, you also have probably heard of the 14th Amendment, which was adopted later, after the Civil War. So the Bill of Rights includes explicit provisions, but it also includes the 9th Amendment. And the 9th Amendment specifies that the enumeration of explicit rights in the Bill of Rights should not be construed to prevent the recognition of other rights that are retained by the people. So in constitutional jargon, we say the 9th Amendment presupposes the recognition of non-textual rights, rights that can be identified not by the language of the Constitution, but rather through other means, fundamental principles of constitutional rights and underlying values. Now, I must have pressed the wrong one, sorry about that. Early on, the United States Supreme Court held, in a case called Barron versus Baltimore, that the provisions of the Bill of Rights applied only to the United States government and did not apply to the states. So nothing in the Bill of Rights itself limits what the state of Kansas can do. But in the 14th Amendment, Congress and the states ratified special protections for citizenship, for the privileges or immunities of United States citizenship, for due process, and for equal protection. I ran out of room. So P&I is privileges and immunities, due process is DP, and EP is equal protection. Now, in another early case, not long after the adoption of the 14th Amendment, the United States Supreme Court construed all of these provisions very, very narrowly, so that they protected virtually no rights. This was part of the court's general movement away from Reconstruction and its constraint of the Reconstruction process during the 1870s and 1880s. Okay, so around about 1890, we start to see the Supreme Court recognize more rights under the 14th Amendment. And one thing the court began to do is to say that some provisions of the Bill of Rights were incorporated by the 14th Amendment and therefore applied to the states. Now, one interesting feature of this was that the court did not use the Privileges or Immunities Clause, which is the natural provision for protecting substantive rights, right? Rights are privileges or immunities of citizenship. So you would think that's where the court would go. But instead, it relied on the Due Process Clause, which says that a person cannot be deprived of life, liberty, or property without due process of law. And so the court said, well, if a law violates this provision of the Bill of Rights, then it denies due process. That's what we mean when we talk about substantive due process. The idea that the property rights, liberty interests, life, right to life, protected by the Due Process Clause includes substantive limitations on laws. Now, during this period, the court's main interest was to protect businesses. And one of the key features of that was the recognition of a non-textual right of liberty of contract, a freedom to engage in contracts. And that was mainly used to strike down laws that protected workers during that period. Minimum wage laws, maximum hour laws, laws providing for unions and the like. Those were all struck down as violations of substantive due process. Now, there were some cases that also involved protection of the right of parents to control the custody and education of their children, or recognizing family rights, also under substantive due process. Now, things kind of came to a head around 1937. There were a series of cases in which the Supreme Court struck down important components of President Roosevelt's New Deal efforts to combat the Great Depression, and he proposed what came to be known as the court packing plan, which would have expanded the court from 9 justices to 15 justices and would have given him the opportunity to appoint 6 justices who would have probably been more sympathetic to his legislative agenda. That plan became essentially unnecessary because one of the justices, interestingly, a justice named Roberts, switched sides and went from a die-hard opponent of regulation of business and economic interests to someone who was willing to uphold them. And that's commonly referred to as the switch in time that saved 9, as a sort of, because lawyers love words. So once the switch in time occurred, once the court changed direction, it repudiated all of these old cases about liberty of contract and said, you know, that was all improper. That was judicial activism. That was the court substituting its judgment for the judgment of the people's elected representatives. And so the court repudiated that kind of activism. But even as it was doing that with respect to liberty of contract, the court began to protect other rights, also rights that were not always textual in character. So most of the other provisions of, I forgot to keep up. Most of the other provisions of the Bill of Rights were incorporated during this period, although some rights were not incorporated until very recently, such as the Second Amendment, which was incorporated in a case called McDonald. Most of the Bill of Rights provisions were incorporated, and then the court also decided a series of cases recognizing the right of privacy. So the court preserved the family rights cases from the Lochner era. It didn't overturn them, and then it began to expand those cases. In the 1940s, there was a case called Skinner versus Oklahoma, where the court struck down a law that provided for compulsory sterilization of individuals who were convicted 3 times of certain criminal offenses. In the 1960s, the famous case of Griswold versus Connecticut, the court struck down a law prohibiting marrying couples from using contraceptives. And also in Loving versus Virginia, the court said that the right to marry was fundamental and that states could not prohibit interracial marriage. And it's these cases that lay the foundations for Roe versus Wade and Casey. So the court was expanding the concept of privacy conceptually. So from the court's perspective, this right of privacy that was reflected in things like prohibitions against sterilization or the right to contraceptives, that was essentially protecting the right of each individual to make autonomous decisions about fundamental issues concerning their own life. And intimate personal relations like marriage, family, and the like. And so in Roe versus Wade, the court reasoned that terminating a pregnancy was within that sphere of personal autonomy, just like the decision to use contraceptives or the decision concerning who you might marry or whether to be sterilized. And that's the same kind of reasoning that the court used more recently in Lawrence versus Texas to recognize the right of same-sex couples to intimate personal relations in the privacy of the home, and the right of same-sex couples to marry in Obergefell. Now, all of this involves questions about how courts examine the legality of statutes that limit individual behavior. And over the years, the court has developed various tests and levels of scrutiny. In most cases, the court applies what's known as the rational basis test, which is a baseline test that is very deferential. Under the rational basis test, the government has to have a legitimate interest to support its laws, and its actions must be, or the measures that it adopts, must be reasonably or rationally related to those interests. It turns out that this kind of test, this kind of analysis, almost always results in a law being upheld, and very rarely results in a law being struck down. It was the rational basis test that the court applied to business regulations, minimum wage, maximum hour laws, and the like, to uphold those laws. Now, in some areas, the court applies a much more difficult test known as strict scrutiny, which almost always results in a law being invalidated. Under strict scrutiny, the law has to serve a compelling governmental interest, and the law must be necessary to achieve that interest in the sense that there's no other way that would be less burdensome on the rights in question. And it also has to be narrowly tailored in the sense that it has to precisely target whatever interest the government wants to promote. It can't be too broad, And it also can't really be too narrow. It can't only tackle part of the problem, because if the problem is really that important, it should reach everyone who would be affected by it. So it's the strict scrutiny test that Roe versus Wade adopted and applied to abortion regulations, and that's what gave us the trimester framework that you may have heard about. Under the Roe framework, the court held that the government had an interest in protecting the health of the mother, but that interest became compelling only after the first trimester, because before the first trimester, abortion was safer than childbirth. And then the court said the government also has an interest in protecting the potential life of an unborn child, but that life only became, or that interest only became compelling after the second trimester or the point of viability. At least at the time of Roe, that was roughly the point at which an unborn child could be viable. So once the child was viable, then the government had an interest that was compelling enough that would enable it to ban abortion, except where necessary to protect the life or health of the mother. So that's what Roe did. The composition of the court at the time of Roe was actually very strongly pro-abortion. It was a 7-2 vote. It wasn't all that controversial, and it wasn't divided among liberals and conservatives. One of the dissenters was Justice White, who was appointed by President Kennedy, for example. And Chief Justice Warren Burger, who was a Nixon appointee, was one of the parties and justices in the majority. But over time, support for Roe on the court eroded as justices who were less supportive of abortion rights and some who were steadfastly against them were also added to the court. And there were 3 justices, all appointed by Republican presidents, Justice Souter, Justice O'Connor, and Justice Kennedy, who staked out a compromise position in Planned Parenthood versus Casey. And under this compromise provision, the court recognized abortion as a liberty interest that was protected, but it didn't call it a fundamental right. And because it didn't call it a fundamental right, it didn't apply strict scrutiny anymore. And instead, the court recognized an interest that was present throughout a pregnancy in protecting an unborn child, and adopted a test called the undue burden test for abortions before the point of viability, and also permitted the state after a viability to ban abortions. So Casey was a fairly stable compromise at the time. It lasted for a little while, but as I'm sure you know, there was an ongoing conservative critique of Roe and more broadly the substantive due process right of privacy that the court had recognized. And this criticism was very similar to the criticism that was leveled against the court before the switch in time, the Lochner Court, and its protection of liberty of contract. So the critique emphasizes that if you're going to recognize rights that are not in the text of the Constitution, then you run the risk that courts are going to just pursue their own policy preferences, that they're going to act as a kind of super legislature and substitute their judgment for that of people's elected representatives. And that was the charge that was leveled at Roe. So critics said the conceptual expansion of the right of privacy, it was no better than Lochner. And the only sure basis, these people would argue, for recognizing rights was either the text of the Constitution or the historical understanding of the framers. These justices advocated an approach under which you would only recognize rights that are deeply rooted in our history and traditions, And you would also define rights as narrowly as possible. So to illustrate this point, this perspective would look at a question of same-sex intimacy and say, is there a right of homosexuals to engage in sodomy that is historically grounded in going all the way back to the time of the founding, as opposed to the conceptual approach, which would say, are intimate personal relationships protected? So this approach makes it much more difficult to protect new rights. Now, this is where I need you to click on the link button there. You get that? There we go. So this is the slide that I like to use for my students. And so the liberal conceptual approach views rights as a big tree that are then deeply rooted in our history and traditions. So you have things like marriage, children, family, contraception, abortion, intimacy. All of these rights are part of the same general right of autonomy and privacy. And those rights, broadly understood, are deeply rooted. The conservative approach says, no, the right way to do this is to look at specific rights. Marriage, is that deeply rooted? Children, is that deeply rooted? Family, is that deeply rooted? Contraception, is that deeply rooted? Abortion, is that deeply rooted? And intimacy, are those rights deeply rooted? Now, Dobbs says, looking at abortion separately, that's not deeply rooted. We can't find history and tradition protecting abortion rights going back to the time of the founding. In fact, they found exactly the opposite. And so that right no longer receives protection. Now, the question is, how far does that kind of reasoning go? If you look historically for a right of, let's say, same-sex couples to engage in intimate behavior, you're not going to find it. If you look for a historical right to use contraception, you're not going to find it either. So that's when you hear people talking about how Dobbs might undermine other rights. That's what they're really talking about. This approach where you have to look for a very specific right grounded in history. Can you take me back to the previous slide? Thank you very much. So these two different approaches coexisted on the Supreme Court for about 40 years, from the 80s to the about 2020. And so there were some cases that took the specific right view, and there's others that took the more conceptual view. And they were sort of back and forth, almost like volleyball. So Dobbs, in overruling Roe and Casey, characterizes the conceptual approach to rights as fundamentally improper. Only specific rights with deep historical roots can be protected. Abortion lacks those roots and therefore is invalid, and therefore they should leave it to the states and the political process. Now, one thing you probably heard people talking about is respect for precedent. We use the Latin term stare decisis, already decided. And the court indicated, or the conservative majority, that if the decision is wrong, it should be overturned. And so they were unwilling to give respect to that precedent. And the example that they gave was, well, Brown versus Board of Education overruled Plessy versus Ferguson. We're correcting a historical wrong just as Brown did. Another part of the discussion which baffles me, and there's much in the case that baffles me, was the idea that, well, one reason why you respect precedent is because people rely on the law as it exists. And the court said, well, Roe had not generated any reliance interests, which I think is a surprise to a lot of people who were relying on it. Anyway, so there is limiting language in the opinion where the court says, well, just because we're overturning Roe doesn't mean any of these other rights are at risk. And the court distinguishes abortion on the ground that there's a countervailing interest. Only abortion involves a termination of another life, and therefore, don't worry, contraception, same-sex marriage, they're not on the chopping block. Now, Justice Roberts wrote a separate opinion in which he says, I'm ready to go after those other rights as well. And the language that purports to limit the case to abortion is about worth what the paper that it was written on, because the court can easily disregard it. So going forward, the court indicated that the rational basis test will apply to abortion. So that means that most limits on abortion would be valid because the state has a legitimate interest in life. But some extreme laws might be so arbitrary as to violate even the rational basis test. And then, as we talked about, other rights, the reasoning threatens other rights, and the limiting language may not provide much protection. Justice Thomas was explicit. I feel like I've used up all my time. I did have one more slide to talk about abortion rights in Kansas. Is that all right? Okay. So some of you may be familiar with the fact that the Kansas Supreme Court has recognized the right to abortion under the state constitution in a case called Hodes and Nauser versus Schmidt. And that decision relied on a separate provision in the Kansas Constitution, Section 1 of the Kansas Constitution's Bill of Rights, which is broader, it's worded more broadly than the Bill of Rights and Due Process Clause. And so the court said it protects more rights than the federal Constitution and provides greater protection. And the court then recognized the historical right, a fundamental right in Kansas to bodily integrity. The court relied on historical basis for that and indicated that that right of bodily integrity included a woman's right to terminate a pregnancy. And the Kansas Constitution rejected Casey's undue burden test, and the court instead applied strict scrutiny. So after Hodes, Kansas protection for abortion rights was even more broad than federal law. So most of you know that there's a proposed constitutional amendment on the ballot in August, and that amendment would negate the right to an abortion under the Kansas Constitution. As I read the amendment, it would permit the state to ban abortions altogether with no exceptions under any circumstances from the moment of conception until birth. The language is kind of confusing. It says that the legislature may take circumstances like rape and incest or birth defects into account, but it doesn't have to. So the court could, the legislature could ignore those. The legislature specifically chose August primary elections to put the amendment on the ballot because they assumed that there would be more anti-abortion activists turning out to the primary season than in the general election. There might be more pro-choice activists. So I think Dobbs then means that the stakes for this amendment are much higher. Approval of the amendment in Kansas would essentially remove all protections for abortion in the state. Now, unlike some other states, Kansas does not have any trigger laws that went into effect or would go into effect automatically. But I think given what we know about the Kansas legislature, we could expect some very restrictive laws to be enacted if the amendment passes in August. So I hope that's helpful background. Thank you for your attention, and I apologize for going over time.
Thank you, Rick. It was very enlightening. I have to spend a little time talking up here while Valerie gets Betsy's PowerPoint up. I should point out that, you may have seen this in the paper, that the Secretary of State in Kansas has opined, and it's true that anybody can vote in the August primary, even if you're registered as an independent or unaffiliated, I think it's in Kansas. So you wouldn't have anything else to vote for, you wouldn't have any people to vote for, any candidates, but you can vote on the amendment. So now, Professor Esch, Betsy.
I sound weird. It's allergy time for me, and I filled up on allergy medicine before I came, and I'm a little wired and also dried as a dried out leaf from allergy medicine. But I can function, so there we go. But forgive me for needing to fairly frequently use the bottle of water, and also just to make sure I know how to use this very sophisticated technology, which has not yet come to my classroom at KU. And I echo my colleague Paul in thanking very much all of you for coming tonight, for being part of an organization, a community, a congregation that is providing this space, making these conversations happen. It's incredibly, remarkably wonderful timing that this happens to begin, this month-long happens to begin right this week, but it would have been important and excellent timing even if we hadn't heard from the Supreme Court on Friday, because we would have been waiting to hear at any rate. So thank you to Valerie and to Eleanor and Paul, and very importantly, I want to add a thank you to Elise Higgins, who I have known in her life mainly as a graduate student at KU, and you are lucky to have her in your community. We are very lucky to have her in our community in Lawrence and in Kansas. Elise is a tireless worker for the rights of humanity, and has a very broad conception of how care matters in what we do. And I've learned a lot from her. So thank you, Elise, also for extending the invitation on behalf of others. I'm going to speak sort of biographically. I'm going to share some experiences that have led me to the positions that I hold and that influence what I study and how I study it and what I teach. So that personal history will be located via the slideshow in what was happening, what I experienced unfolding in my lifetime around the question of reproductive self-determination, as I began to call it when I was a student in the late 1980s. And I do bring in some Kansas history because it's important in the bigger history, but I just want to be sure to stress that I did not live in Kansas at that time. I've lived here for 7 years, and so I was not, while I was a participant in some of what I'm about to talk about, I was not a participant in the stuff that happened in Kansas. And maybe some of you were, in fact. I will not be at all surprised if some of this is very familiar, tragically or otherwise. And Kansas is, sadly, maybe if we don't want to evaluate it, we will just say, in fact, Kansas is deeply important in the history of the anti-abortion movement. And so talking about it as people who live in Kansas, even if we are people who don't identify with what Kansas has come to stand for lately in the eyes of the rest of the country and the world, it gives us a certain responsibility, urgency, I'm not sure. And after many years of participating in debates and thinking about and reading about reproductive rights, reproductive freedom, reproductive control, and simply, not simply, deeply, deeply, deeply complicatedly society, I haven't changed my mind all that much from the thoughts that I came to have in 1989, which is where this story starts for me, and very importantly in the history of abortion rights is kind of a turning point in our country as well. And in fact, I think we could argue that the early 90s, and I would say the formation of the organization Operation Rescue, which I'll talk about, is sort of marks the kind of beginning of this phase of this movement, and that maybe we are in a new phase since last Friday. Certainly something big has changed. Understanding what that was will be up to all of us. And sorry, I need to drink some water. But I believed in 1989 and through the 90s and through the 2000s and through the 2010s, and still, that the best chance we have of defending the right to abortion in this country, not because I don't think the same would be true in other countries, but I don't happen to live in those, is to build a broad movement for protection of the rights of women that includes the whole spectrum of health care and reproductive health care, but also the rights of women as political beings and social beings. And now, as we are facing a society that's very beautifully changing, and we are being asked by transgender people to even think differently about how we name and understand a woman, which is a wonderful thing to be able to have a new kind of page in how we think socially. But that broad, that idea of a broad coalition, a broad way of thinking about abortion rights, isn't just to be inclusive of all the things that women need to be able to have what we would call reproductive health. It's also to think about how all the things that matter to us, I suspect that matter to most of us in this room, are connected, and that really it's not possible to separate them. So that's sort of where my comments are located in that sense, that the social justice movements that we support and participated in are very, very importantly connected. And this is one that tends to kind of be put over here and thought of as distinct. And I think that's actually a political conclusion that's been created through the lobbying of conservative anti-abortion activists. And I'll say something about that too. Okay. So my story begins in the summer of 1989, not 1889, 1989. The summer of 1889 may have been more exciting than the summer of 1989 from the point of view of political change, not sure. I was a college student on the verge of dropping out of school in Michigan that year. I was preparing to travel to the Middle East on a student solidarity eyewitness to peace delegation to observe and account for U.S. military and defense aid to the Israeli occupying army in the Gaza Strip and the West Bank. And that trip became life-changing, and it was ultimately the first of many that I would take to that region. That summer, I also joined millions of people around the world and in South Africa in protesting the continuation of the vicious apartheid government. And that was a movement that reached its zenith in 1989. And by early in 1990, Nelson Mandela had been released from Robben Island, where he had spent 27 years incarcerated, doing hard labor. And the African National Congress, the organization of the majority of South Africa, had been unbanned. 1989, of course, also, though not that summer, but that year, we saw the coming down of the Berlin Wall. And it was also really importantly and really relevant to this discussion, though we don't always situate it that way, also was the year in which ACT UP, the AIDS Coalition to Unleash Power, became a force of some very big significance in U.S. history. Some of these things not as evident in Kansas as they were elsewhere, but yet evident in Kansas. But also that summer, and for me, I spent my weekends rising at 4 a.m. which I have gathered from living here is more something people in Kansas do. It was not something that I did as a college student. Sometimes this just equaled staying up. I will have to acknowledge that fact. But we would rise at 4 a.m. and wait to get the phone call to learn at what clinic Operation Rescue and its allies would be demonstrating in attempt to prevent people from seeking health care in that facility. Clinic defense was a very grueling and awful and demoralizing and depressing thing to do. Any of you who have done it, I think, probably share those experiences, even as you also, I would imagine, remember it as I do, as incredibly important, as vitally necessary, and hard to know what would have happened had we not been there. Clinic defense, for people who don't know, was the act of bringing our physical bodies to places where reproductive health practitioners did their work and women sought care, and that care included abortions. And those clinics were targeted by the anti-abortion movement almost immediately in the 1970s, but in a movement that really escalated starting in the mid-1980s. We would link arms like this, and so that clinic defenders could not come through, protesters could not come through the wall of clinic defenders, and we would do that for hours at a time, as escorts from our organization would, also volunteers, and mostly men, would meet with the women who were seeking health care and help them get into and literally physically get through the line of people screaming obscenities at them. Because we were there, those doors remained open. If we had not been there, those women would have gone home. Many did go home at any rate. It was frightening. It was very ugly, even obscene. And I tell this story to my students because I find, today I was working on this talk and I was getting kind of, just having big feelings. And I was remembering that we stood like this for clinic defense when we were all linked in arms. And at one point, at some number of weeks or months into this, the Operation Rescue started bringing their children with them to these protests, and that was confusing and sad and difficult to see because of the nature of the propaganda that was being used by the anti-abortion movement. But then quickly we learned that those children were being asked to play a role in their demonstrations, and so instead of standing like this for hours on end, we stood like this for hours on end so that small children could not run through our legs and into the healthcare facility. And I find that just so, powerful in its physicality, and also powerful in how it describes the tactics and the approach that anti-abortion activists have used for 3 decades, and through which they have accomplished things. And we have to say that they have accomplished things. In 1989, when I shared this with you all, this is a resource I kept. This was made before Friday's decision was announced, but it's a exploration of all the ways that abortion is both legal and not readily available in the United States, again, before Friday. I shared it because I'm a big fan of Padma Lakshmi from Top Chef, and the art is done by Molly Crabapple, who's a family friend of ours, so you'll have the link when you get access to the broader thing. Okay, where am I going the wrong way? Okay, and I didn't truthfully realize we were going to be in such a large space, so I apologize for the small type, but I will say, and very briefly, 1989 was the year that the U.S. Supreme Court decided the case of Webster versus Reproductive Health Services, a case that came to them from the state of Missouri. And the state of Missouri basically brought to the court a set of ideas, and I'm not going to sound in any way as learned or focused as Paul would, so we will be directing all future questions about the Webster decision to Paul. But it was basically the decision that said all the things that have to do with getting access to getting an abortion are not protected. That the Roe decision can be separated out from funding, having a place to go, having a medical doctor, having access. And so we, at that time, I went back and looked through some of my old files preparing for this, and I found several articles written by friends and colleagues in the social justice and feminist movement, and nearly all of them started by saying that the Webster decision represented the end of the Roe versus Wade decision as we knew it. And I think that in a very important way that was true. I mean, it's certainly the as we knew it part was true. And it certainly is true in the sense that it created the template on which most of the subsequent attacks on abortion rights have, sort of the platform on which those laws have been launched as campaigns, turned into propaganda, turned into ideology, and then made into law. And we now have, a couple of generations of young women who only lived with a relationship to abortion through that very foreclosed sense of access. So in getting that shot in the arm that the Webster decision gave them, the anti-abortion movement was also in the process of coalescing, bringing itself together, getting organized. And most importantly, that was through the launching of an organization called Operation Rescue that was started by Randall Terry in 1986. I keep going the wrong way with the clicker. It's kind of counterintuitive, that clicker. And one of the things that these activists did was to create wanted posters that showed and bore the names of abortion providers in the United States. And now these posters these come from the internet, and they've been redacted for good reasons. So I don't have originals. And because of some changes in law, it's not very easy to get access to these, which is also good news. But the first one on your left is a wanted poster for Dr. George Tiller, and in the middle, David Gunn. And then on the end here, a list of abortionists. And you probably can't tell, I'm sorry for the size, I wasn't thinking about our space. In the wanted George Tiller, they took the word Wichita and attached it to the word Auschwitz to make Auschwichita, the word that was associated with the health care that George Tiller provided in his clinic in Kansas. These posters were put up largely in communities where these healthcare providers lived and worked, their neighborhoods, their front doors, their parking lots, probably their children's schools, although I can't document that. And I want to take a page from the new generation of activists who are out in the streets, who were out there in the streets holding up signs since Friday. I think they've been in South Park Friday and Saturday and Sunday, but also in the streets in Ferguson and Minneapolis, and the leadership that's coming from them has some really wonderful things it contributes, and one of those is the phenomena of speak their names. And I just want to speak the names of the 7 people who in the 1990s were murdered in the act of trying to ensure that women could actually access the abortions that were their legal right. David Gunn, Florida, 1993. Dr. John Britton and James Barrett, also in Florida, 1994. Those at a clinic that had been bombed in 1994 and would be again in 2012. In 1994, Shannon Lowney and Lee Ann Nichols, killed in 2 separate clinic attacks in Massachusetts. Both these women were receptionists. Robert Sanderson, an off-duty police officer who worked as a security guard, volunteered to provide security to an abortion clinic in Birmingham, Alabama, was killed when the clinic was bombed. In 1998, Barnett Slepian was shot to death with a high-powered rifle in his home. Those 7 were, how many of you knew that? 7. How many could have sort of remember that or sort of think you once knew that? Not most of us. And so that alone tells us something, that people who were murdered in the act of doing something that was a legal right were gunned down for doing it. And at least half of them were men, is a big thing. It's a big thing, and I don't know how to completely make the meaning out of it. I think we all have to make the meaning out of it ourselves, but when we come to the ways in which the talk that we talk about is a moral consideration, as Valerie urged us to at the beginning of this conversation, and not just a political conversation, or not just a conversation about law and history and jurisprudence, all those things being important, and all those things, frankly, being where I spend my time teaching. It is remarkably important to recognize how something shifted so profoundly that history didn't completely go in the other direction when we saw these things happen. In 2009, George Tiller was killed. He'd been shot once before in 1993 in front of his clinic. This time he was killed in his own church in Wichita, Kansas, where he was working as an usher. And it's hard to fathom a comparative, event if a KU basketball star or a Koch family member were gunned down in their church, or were gunned down with somebody who this state didn't in the main agree with in its policy direction, what the results would be. So the Operation Rescue began, how do I not remember this each time? Oh, thank you, okay. You could have said that minutes ago, Paul. But I've also, okay. So very quickly, because I'm kind of feeling so emotional that I'm not paying close enough attention to time, and I don't want to take too much more of it. 1991, Operation Rescue descended on Wichita, Kansas. Does anybody here remember these events? Thousands of anti-abortion protesters came to Wichita from all over the country to take a stand. Though this picture, again, you can't see because of scale, but you can see in the background, George Tiller's name is on the sign of the clinic in front of which these activists are standing. And they effectively ended the business of that clinic during the time that they were here. The police did get involved at some point, and in fact, it was the goal of Operation Rescue not just to close the clinic, but also to get arrested and fill the jails. And that was the moment in which Operation Rescue came out as an organization linking itself, ideologically no, but practically and logistically, to the long African-American struggle for freedom. Paul referenced it in relationship to the 14th Amendment, Reconstruction, and here, of course, they're referring to Martin Luther King and this fill the jail strategy that was so wonderfully used in the 1950s and 1960s in the South, in the Jim Crow South. Over 1,600 people were arrested in 3 weeks. Thousands and thousands of local gatherings and clergy were involved. Ultimately, by the time it was over, after 6 weeks, 2,600 arrests, culminating in a rally featuring televangelist Pat Robertson. And I think people who write about that time say we can't underestimate the impact on both Wichita and Kansas politics that those events had, and I think that is correct. oops, this is just completely beyond me. That same campaign was carried out in Buffalo, New York a year later, and it completely failed. By then, the people who were defending the rights of women and defending the right to abortion had gotten organized. There was, in fact, more of them in northern New York than there had been in Wichita. And the campaign that had been so successful in Wichita failed in the streets of Buffalo in 1992. Now, this was important for a lot of reasons to the movement and to the idea of kind of direct action and how we might confront it as people who were the ones defending the law. And this is just a photo of the main health service where arrests were targeted. And there were thousands of arrests there as well. But ultimately, that strategy failed. The biggest and most impactful moment of that, however, was the televised event of the 1988 Democratic National Convention, where Randall Terry and supporters of his were on television being arrested in a civil disobedience campaign outside the Republican National Convention in Atlanta, again borrowing a page from the civil rights movement. In 1988, they blockaded 182 places of care, were arrested. Almost 12,000 of their members were arrested. I don't want to say 12,000 individual people. There were 12,000 arrests. Some people arrested many, many times. By the end of 1990, they had racked up $500,000 in fines for the destruction, much of it being considered misdemeanor, but also they were receiving at that time $1 million in donations that was publicly known to us as a 401c3. We don't know about other forms of payment. When we go forward from that moment, a couple of things are really side by side, meaningful and important. One is that there was a recognition that the kind of violence that was happening at clinics and the kind of violence that resulted in the early 90s murder of abortion providers was unacceptable, and there was a bipartisan sense of that. Ultimately, in 1994, the Freedom of Access to Clinics Act was passed. It was called FACE. FACE was passed. And this effectively ended the disruption of business at abortion clinics. Now, it did not prevent people from demonstrating in front, but it did prevent people from carrying out terrorist or otherwise violent prevention of people of access to those clinics. But the other thing that happened when FACE was made into the law of the land, it turned into the two sides. So there were the anti-abortion people and the pro-abortion people, and we were reflected in being the two groups on other sides of the sidewalk, near the clinic, but not in front of it. That was how the law played out. And I want to say that was a moment when we lost something important, another moment when we lost something important, because the people who were in the streets defending something that was a legal right of women and a legal right of healthcare providers were put on the same plane of ideology and opinion as those people who were fundamentally out there set to disrupt and prevent the provision of those services. So that sets a stage that a lot of what comes after, including the speeding up of legislation being passed so much that I learned this week from a friend that Kansas is now a state that is actually a place where people come seeking abortions, because we are so surrounded by states where it's not possible to get abortions before the Friday decision. So women from Missouri, from Texas, from Oklahoma come to Kansas, even though we have only 3 places where you can get an abortion. That's a kind of remarkable statement about how things around here are. I'm going to conclude by saying kind of going back to where I began about what does it mean to say we need to fight for abortion rights as part of a whole agenda. I think what I mean is, well, two ways I want to conclude and say that. One is to say, I think the right-wing move in the United States and the explosion of conservative ideology and practice in this country owes a debt to the work of these illegal, terroristic, some of them, demonstrators in the 1990s in particular. And they created a space for reasonable conservative politics to become spoken and embraced and shared, and for the rest of us to feel stigmatized and awkward, perhaps impolite, if we are talking about these matters. But that process is what shows us, in fact, how significantly this one issue was wrapped up in a package of things that are socially relevant and meaningful: immigration detention, incarceration, voting rights, and perhaps most importantly to me, just the idea of what young girls can imagine their lives to be. What young girls imagine their country has in mind for them as they grow up. And it's a shocking and strange disconnect that every day this week we celebrate Title IX, and it's 50 years since it passed, and there's some wonderful television programs about this, even as we, I think, mourn something that's a very big loss, because abortion as we know it did end in 1989, but the right to abortion did not. And now the right to abortion has been declared not of value in this country, and we will see where that takes us. And I look forward to being part of that conversation with all of you and hopefully many, many others as we move forward. And I hope we can share in the conviction that speaking out loud about what has happened and what will happen is part of our responsibility. Thank you.
Thanks, Betsy. Before we get to the cards that Valerie is picking up, pass yours to the aisle, right, if you have a question. I have a question for Rick.
Is this working?
Yeah. So Dobbs now says that laws relating to abortion must be judged on a rational basis test?
Yes.
Yes. So what's your, so back up. There's been a bill introduced in the Kansas legislature that would prohibit abortion except to save the life of the child. I don't get that one, but to treat an ectopic pregnancy, or when the fetus is already dead inside the womb, that those would be the only exceptions to a total ban on abortion. Of course, we don't know how the amendment's going to come out, but so how do you think the rational basis test would apply to draconian laws like that?
Well, I'm hesitant to predict because I feel like doctrine, which is what I've been teaching in constitutional law for almost 40 years, doesn't seem to matter anymore. And what matters is what judges think. So I think there's an argument that even if there's a legitimate interest in protecting unborn life, that sort of an extreme measure is an irrational way to accomplish that. I also think there's an argument that law deprives women of their right to life by preventing life-sustaining treatment, which might justify applying something more rigorous than the rational basis test. So I think there are arguments against the constitutionality of a statute like that, even after Dobbs, but I don't have confidence that those arguments would be given a fair hearing any
do I just do this? Can you hear me? I would just add very, very plainly and with all respect to Paul's work and his analysis and our absolute need to understand the legal complexities and et cetera, I would really, really add, however, the plane of human rights, that we need to be able to think about how we move in a conversation from legal and political rights to a consideration of what are human rights. And again, reproductive health in its broadest sense. I'm astonished every year when I teach this large lecture class at KU that when I ask the students how many of them have had any access to birth control information in their schools, the answer is almost entirely always zero. It's just astonishing to me. And yeah, so just to see the legal work that has to be done and that will be done, thank you, as part of a whole.
I just follow up on that. I would add that the point is we can't rely on courts to protect these rights. That they are rights that have to be secured politically. They can't be secured by courts.
All right. There's a lot of excellent questions here, and some of them overlap a little bit, so I'm going to, even though, Rick, you just said that we can't rely on courts, there are a lot of questions about courts on our minds. So,
That's fine. That's
okay,
fine.
all right. So either of you can address this, but two of them are substantively similar. In the confirmation hearings, there was a lot of discussion about precedent and a lot of posturing and gesturing towards the maintenance of Roe as something that was secure, and then the script flips. What do we have any recourse? What's that about?
Okay. Well, in theory, if a justice were to lie under oath, that would be the commission of a crime, which could provide a basis for impeaching the justice. But I think the chances that any kind of measure would be taken on that basis are very small. It's not even clear that they lied. They certainly intended to obfuscate, but whether they actually lied is in the eye of the beholder. I guess I also personally would be a little concerned if justices are impeached because of their decisions. I'm not sure where that ends, and whether we wouldn't have a kind of tit-for-tat response.
Yeah, if anyone's watching the hearings about the behavior and comments of our president January 6th, then it's hard to imagine if we have a country that about 40% still maintains that President Trump did nothing wrong at all and actually did good things that day and alongside others. It's hard even to imagine what it would take to get to a point of creating such a groundswell around an impeachment of a jurist, and energy much better spent on other things.
We have a lot of excellent questions on cards here, so we're going to prioritize some of these. We won't get to them all. I'm sorry. It's possible that, I'm sorry?
Do you want to clump some together?
Well, I was trying to, yeah. There's a couple questions that I think are really salient. One about where do we go from here, and particularly about Kansas and the constitutional amendment. What are the options for people who are invested in seeing their interest in preserving abortion rights manifested in Kansas apart from the courts? Voting, clearly, but are there other things? What can we do? What can we do here in Kansas?
Well, we could, so there are a lot of different kind of strategies that have been suggested. As some of you know, our local DA has pledged not to prosecute violations of anti-abortion laws. So locally, there might be ways in which you could mitigate harms. Activism in support of access through helping women travel if they need to in order to gain necessary access would be another strategy. But I tend to think that this is, the anti-abortion movement has spent 50 years to get to this point. And if you really want to protect women's health and reproductive rights and all of those things, I think a similar kind of long-term grassroots effort to build support for this at a political level is where you have to go.
Josh? I ditto. Same. Okay, I think we probably have time for one more, and I'll try to clump a few of these together. There's a lot of questions about the history of the Supreme Court and making decisions like this. I think, has the Supreme Court ever been as political as it is today? How can they require a previous case to be cited when many of the topics were never discussed above ground? What point can precedent be set in the first place? Women have only had the right to vote for 102 years. Do we have precedent? Some of these questions about where are those roots, I guess? What counts as roots and where are these precedents coming from? How is it so political?
Well, at the risk of sounding like a critical race theorist,
Okay.
the reality is that the definition of rights that is grounded in history and tradition privileges the views of white men of property at a time when women, African Americans, Native Americans were not part of the political community. And I don't think it's an accident that this approach to interpretation is advanced by conservatives. I read someplace, at the risk of offending people, I read someplace that the single proposition that defines modern conservatism is that there must be some people that the law protects but does not bind, and other people that the law binds and does not protect. And I see, for most of its history, the Supreme Court has been on the side of privilege. And there, I grew up, I came of age in the 60s and 70s, and I kind of thought of the court as a force for progressive change. But those decades represent a very small portion of the court's history. And the rest of the court's history is, governed by, proving the oppression and taking land from Native Americans, Dred Scott, Plessy versus Ferguson, anti-union, anti-labor, anti-women decisions. So I think that I come back to my view that you can't expect the court to do these things. They have to be done by people.
I'll just add, when I teach the 1850s and the period leading up to the Civil War and then just after the Civil War, the 1850s was a time of real reaction, conservative backlash against the advances that had been made by the anti-slavery and abolitionist movement. In the Dred Scott decision that Paul just mentioned famously, that the Justice Taney in his decision said the black man has no rights that the white man is bound to respect. And it said if you're a slave in the South, you're a slave wherever you go in the United States. And that decision came alongside of a package of legislation, including something called the Fugitive Slave Act. And the Fugitive Slave Act criminalized the act of giving aid to a slave escaping, to an enslaved person escaping from bondage. So if you were in Boston or you were in Kansas, if you were found to have aided or abetted in any way, and most of the people who did so at the time, we should say, did so as persons of faith, they were criminalized and could be jailed and fined. and their neighbors for turning them in could be rewarded. So when I teach that, I say to my students, where do you imagine you would have been then? And let's really try and be honest. Where do we imagine we would have been then? And I think mainly the answer they give is fearful to be in trouble, even though they knew what was right, the white students among them. And I find that very profound, and I think trying to engage with what it means to confront injustice. And we have amazing examples of it in United States history, but also just in the history on this continent, which is peopled far and deeply and broadly and complexly before the United States ever came to be a part of it. There is a lot to think about, and dogged determination, and I think maybe this is a moment of dogged determination and really supporting one another in that. So.
Well, I want to thank our speakers again for giving up their Wednesday evening. It's been very interesting, and thank you all for coming, and they might hang around for a few minutes if you have questions that weren't answered. So thanks a lot.